All right, welcome everybody. My name is Jack Deckers. I'm a faculty member in Department of Animal Science, Animal Breeding and Genetics at Iowa State University, and I'm one of the co-PIs on the Agricultural Genomes to Phenomes initiative and leading the field day component. So today I'm excited to have us talk about IP in livestock and plant genetics and breeding. And we have two experts in the field, two patent attorneys who work in the area, are going to talk to us about IP and all the issues associated with, because as you know, even in academia, we more and more either directly or directly are running into or have the opportunity to think about IP or have to use IP or patented technology. And so it's important for us to be aware of what the rules are, what the issues are, how things are different between plants and animals, and so on. And so we have Tom Eisenbarger and Dan Lorentzen. So as I mentioned, they're both patent attorneys. Coincidentally, they're both located in or around Madison, Wisconsin. So Tom has worked as a patent attorney for 12 years, and he's a senior shareholder with Casimir Jones, which is a life science focused intellectual property firm in Madison, Wisconsin. And Dan Lorentzen is the chief intellectual property counsel for Genus PLC, which is a livestock genetics company out of DeForest, Wisconsin. As I mentioned, both are patent attorneys, but both also have a strong background in biology because they both have a PhD related to biology. Tom in biomolecular chemistry and Dan in immunology. So they know the biology, but have the expertise also in patent law. And so Tom will start and he will talk about patent law in the US, both what the laws and the policies are and practice, and provide us a framework for understanding the law. And then he'll talk about practical problems, issues, and questions relating to patent law that life science researchers often face. And then we'll have a brief question period, and then Dan will talk about the view from industry of IP that is developed in academia and how such IP is valued and assessed. And he'll also talk about the current state of patentability in the agricultural space and differences between the US and other countries, and also differences between plants and animals, because there are quite substantial differences there that are important to understand. So with that, I'm going to turn it over to Tom.
Thank you, Jack. That was a great introduction. Let me get this shared.
Oh, one thing I forgot to mention for the audience, if you have any questions, just put them in the chat. I'll monitor those. And if there's a question that is immediately relative to what our speaker is speaking about, I'll interrupt him. But otherwise, we will leave it to the question periods. Go ahead.
Is that looking correct?
Yes, it does.
All right, great. Thanks, everyone. So like Jack said, I am a patent attorney at Casimir Jones in Madison, Wisconsin. And I've worked for 12 years in this field and with large and small companies, tech transfer offices, researchers, all over the place. So my goal today is to provide some background and a little bit of the policy and theory behind patent law that's generally applicable to the US, but has common themes in most bodies of patent law around the world. So there are some specific things that are important to know, but my goal today is just to provide a framework for understanding why the law is what it is and why certain practices are established. And then ultimately to answer, well, to help everyone understand what patent law is all about and address some of the most seen issues and questions that I've come across in my practice. So one of the things that researchers in the science space often run into or often misunderstand in the patent law. So my goal is to help clarify some of that and just and provide a little more understanding of why we do some of the things we do. So it'll be a little academic here to begin with, which I think is interesting, but also provides a good basis for understanding what the law is and just introducing a lot of the concepts. So first and foremost, what is a patent? A patent is a form of intellectual property. It is something that a person or an entity can own. You can sell it, you can lease it, you can give it to someone else, you can own it with someone else, and it has rights that you can enforce. So in some respects, it's an imperfect analogy. You can think of intellectual property in the same way as real property, as a piece of land or a piece of your watch or your phone or whatever that you own. It's something that you have rights to it, and in the case of real property, a piece of land, you have rights to keep people off of it. You can do things with it. In the case of intellectual property, you can do things with it, and it gives you certain rights. Ultimately, these rights are granted to the patent holder from a government. So in the United States, it's the United States government that has implemented the patent laws that provide a structure and a framework for providing these rights and enforcing these rights. And then a patent can also refer to the actual document itself, which is what I have a picture of here, what it looks like in the United States. Patent documents look different around the world. And this word patent ultimately derives from the letters patent, and patent comes from the Latin word pateo, which means to lay open. So from the early development of the patent laws, a patent is a public document. It's something for all of the public to see. It's a public announcement to the world that these rights are granted to a certain individual. In the United States, the basis for our patent law is in the United States Constitution. So it's something that was contemplated at the formation of the country right from the beginning. It's in the United States Constitution, Section 1, Article 8. I have a little picture here of the actual text in the Constitution that is in the section granting certain rights to the Congress, so the lawmaking body in the U.S. Congress has the power to promote the progress of science and useful arts by securing for limited times to authors and inventors exclusive rights to their writings and discoveries. And this power granted to Congress is sort of sandwiched there between Congress's power to establish post offices and post roads, and then right beneath it is Congress's power to establish courts below the Supreme Court. So it's kind of in this list of things that Congress can do, and interestingly, between post offices and courts. Congress then uses this power to establish legislation, statutory framework for the patent law, which in the United States is in this what's called Title 35. In other regions, for instance, in Europe, the patent law is established by a treaty called the European Patent Convention that countries sign on to and agree to abide by certain laws and practices. And one important note on that is that the treaty that governs the patent law in Europe is different from the treaties that govern the European Union. So sometimes there's some confusion about the European Union and the patent treaty that governs patent law in Europe. So at the end of the day, one question is, why even bother with all this? Why do we have this? What's the patent law good for? So for the government, the policy for the government is to provide an incentive for inventors to make inventions and then teach the public how to make and use them. So it's a way to move things that might otherwise be kept secret into the public domain. Let's get these things published so the public can learn technology and be able to use them. For the inventor, the incentive is to obtaining an exclusive right that allows inventors to recover costs that they have used to research and invest in their technology. And this ends up being a deal between the government and the inventor. That is, the government says, hey, you teach the public how to make and use your technology, and we'll give you an exclusive right to that invention for a limited time. And it is this deal that provides the framework for many of the concepts that are attached to the patent law. So you have to teach the public, so that is why patent applications are typically published, so they can be accessed by the public. The how to make and use your invention is tied to these concepts of the written description, disclosure. So in your patent application, you have to write like what the technology is, how do you make it, how do you use it, all of the text in the patent application that's describing your technology. You have to have an invention. So there's something that has to be new and meet certain thresholds for a technological advance. Who is this you? Who gets the right? Who is the inventor? So that's an important thing, especially in the United States, determining who is the inventor, and then that person, the rights in the patent vest in the inventor, originally in the United States. Those rights are defined by the claims of the patent and give you a right to sue infringers and enforce the claims against other folks. And then this right is for a limited time. So the patent does end after a certain time, in which case the technology is then free for the public to use. So just generally in a timeline of patenting, going from left to right, you start with your great idea. At some point, you'll develop that through research, and then you'll disclose this idea to a patent attorney in an invention disclosure. Patent attorney will draft the text, write the text of the patent, and then at some point you'll file the application with a government or a patent body. Everything that has been published in journal articles or in patent applications that come before that filing date are what we call prior art. So this is all the evidence of what is already in the public. And that's an important concept to remember in the patent world, and a term to remember. And then after the patent filing is this period of time we call prosecution. So this is the process of dealing with the patent office and saying, hey, my invention is patentable, and the patent office saying, no, it's not for these reasons, and doing this dance back and forth with the patent office until you come to some sort of equilibrium of what is patentable based on the requirements of the jurisdiction where you're trying to get a patent. Typically after the filing date is when, if you're an academic, you might have a manuscript that gets submitted for publication and is published, and best practices are for that to happen after you file your application. At some point, if everything goes well, you'll have an issued patent with claims you can then enforce, and then that enters into the enforcement stage, where then you have claims you can assert against other people, other entities that are infringing on your claims. This is what a bit of what a patent looks like. So this is the patent for green fluorescent protein several years ago from the University of California. So the bit on the left is a bit from a patent application we call the specification or the disclosure. So that's all the text that describes the invention, what it is, how it works, what are the different variations and options. It can be anywhere from a few pages to hundreds of pages, depending on how complex the technology is. And then on the right is what is called a claim, which is the legal definition of what you've protected. The important thing to remember in the patent world is that what is on the right side there in the claim must have a basis, or must be described in the text of the application that's found in the specification. So at the filing date, when you file your application, the text, the specification bit of the text, for all intents and purposes, is static. It does not change. However, what part of that you decide to claim in the patent claims and then enforce is fluid. So you can decide different things you want to try to protect, and then during this prosecution with the patent offices, the text of the words of the claims can change based on the rejections you get from the patent office. But ultimately, the claims always have to be based and describe something that is in the text of the application. What being described in the application means is a point of argument and can vary around the world as far as how rigid is that requirement for being described in the application. This claim is an example of a composition claim. So it's claiming a nucleic acid molecule, so a thing. And I just wanted to give you an example of another application that is a method claim. So this is a claim that has a series of steps that someone might perform. And in this claim, the steps are forming fused cell hybrids, cloning the hybrids, and then selecting clones. So this is the original patent describing monoclonal antibodies. And again, there's a whole section. It has the description of the invention. I'm only showing a snippet here. This is about a 10-page patent, but I'm only showing a bit of the text of the specification and the very first claim. So that's the specification and claims of a patent application. So with that background, I've selected about 8 different topics that typically come up in the patent world in my dealings with scientific researchers. And I may not get through all of these, but I'll try to get through at least a handful of them. And my goal would be to prompt questions on your end from your experiences or things you've worried or wondered about that kind of come in under these topics. Firstly, so in the United States, we have these things called provisional patent applications, which it's a patent application that's filed with the US Patent Office. It provides a placeholder in time. And then that application, it just sits there. It's not examined. Nothing happens to it except it just sits there until no more than a year later, where you file a real or a non-provisional patent application that starts the prosecution, the examination process. Sometimes inventors or researchers hear that a provisional patent application is a cheap way to protect a technology. And so the idea of sometimes is to file a very sketchy provisional application that doesn't have much description in it. It's a few pages, and then the researcher thinks, okay, I'm going to file that and then use this year to really develop my idea, and we'll file a full-fledged, multi-page, well-developed patent application at that 1-year anniversary. That is one strategy. I would say in my practice that typically I would not recommend that strategy, and this is the reason. So if in your provisional application you are describing a technology we'll call X, you've described it, you've developed it well, you've talked about all the variations. Maybe you mention some technology we'll call Y. So it's kind of like half-baked. You talk about it, but you don't describe it or develop it very well in text. And then at that 1-year anniversary, when you file your non-provisional application that starts the process in the US, you add text to the application where you fully develop this concept Y, and then you add a new discovery or a new technology in Z. That happens often, but what I think is important to understand is that any claims that you want to pursue to say Z will have what's called a priority date as of the filing of the non-provisional. So it's the date when you describe and file Z, the text on Z, that provides the date for your claims to have a priority date. That means that anything that happens prior to you filing that non-provisional that is related to Z, it could be prior art. With respect to this invention X, this concept X, it was already in the provisional, fully developed, fully described. So for that X technology, prior art that is applicable to this application is anything before the provisional. So you've gained sort of a year of excluding relevant prior art there. So at the end of the day, what this all means is that, in my view, I think it's most important to try to file a provisional that's as fully developed as possible, and not file these very sketchy, bare bones provisionals. Sometimes you have to do that if you're meeting a deadline and you have a talk coming up and you want to file something to protect certain concepts you're going to disclose in a talk. We understand that, but the best practice is to try to file a provisional application that's fully developed. Another thing we often run into is this difference between discoveries and inventions. In particular, I'll take the example of a biological pathway. Often researchers, they'll do great science. They'll discover or identify a new pathway in an organism that's responsible for some disease phenotype or some other phenotype. They'll discover all the enzymes that are involved, how they interact. But the thing to remember is that is something that has always existed in nature. So what has happened is you've discovered something very important and described it, but you haven't necessarily made anything. You haven't developed anything. And so often researchers want to try to protect that pathway, or they want to try to protect a target within that pathway that could be modulated by some unknown chemical compound. Obtaining patents to those types of discoveries is difficult. What needs to happen from the patent world is perhaps developing a new compound that might target that pathway. There needs to be something else. So there often is great science that happens, and it is not always the case that great science can be patented. Another thing we often run into that is related is this idea of, I want to protect the idea of blah, blah, blah. And this, I think, in sort of the common parlance of culture and society, people often think that patents protect ideas. That's how they're often described. But I think this is a dangerous way to think about it, in that patents do not protect ideas alone. You actually have to do something. You have to make something, and you have to sort of use that idea to create something, an invention, a technology that is then in the world and can be used by somebody. In the U.S., we talk about this being invention is conception plus reduction to practice. So conception is the formation of the idea of the invention in the head or the mind of the inventor. And then the reduction to practice is how then do you manifest that idea in the physical world? What is the technology? And the standards for this reduction to practice can vary. For instance, in the mechanical, what we call the mechanical arts or the mechanical technologies, things are very predictable. You take a certain set of gears and chains and levers and you put them together, and it's very predictable how that is going to function. And so a drawing of your technology might be all you need to reduce that idea to practice. In what are often called the unpredictable arts, like biology, where things are more than a combination of parts that work together like a machine, you often need experiments and data to show that your technology works for how you've described it. And following on from that, one question is, okay, I have my idea. I have shown through some data that I have a technology that works. And the question from researchers is often, what can I protect with that data? And this has to do something with something called claim scope. That is, how broadly can I protect this technology? How far out can I push with my claims? So, the example that I just kind of drawn up here is, say you discover a new antimicrobial that kills Bacillus anthracis and nothing more. most likely you'll be able to get a patent claim to that antimicrobial and perhaps its use in killing Bacillus anthracis. Now, if you've discovered that antimicrobial, and it's also known from previous work that there's a common pathway in Bacillus, or you've shown through experiments and data that there is a common pathway in Bacillus, perhaps that you'll be able to get claims that protect killing all Bacillus with this antimicrobial, because there's some predictability based on what you've discovered and what is known as far as like a structure function relationship, targets, conserved functionalities, conserved genes, et cetera. And that if it's known that this new antimicrobial targets pathway known to all bacteria, then perhaps you could get a claim that's very broad for use of that antimicrobial to kill all bacteria. The hard case is, say you find an antimicrobial that kills anthracis, Bacillus larvae, and Bacillus cereus, but doesn't kill other Bacillus species. Then it's like, okay, well, what's common between the things that you've shown can be killed? Is there a common target? Is there a common pathway? What is it that links these together that can be generalized in a patent claim to give you some protection beyond just killing these three organisms? In the United States, inventorship is taken very seriously. It is legally defined, and it is tied up in what I mentioned before, this idea of conception. So the inventor is the person who comes up with the idea of the technology, of the idea of the invention in his or her mind. This has been expressed in court cases in many different ways to try to sort of get at what this idea's conception is. I have two quotes from cases here, that it's the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is thereafter to be applied in practice. For me, I often have to read several of these types of snippets from cases to sort of get my head around what an inventor is. But what is important, I think, for people coming from the science world to remember is that invention is distinct from authorship on, say, a grant or a academic publication. It's not something that can be awarded for effort or to acknowledge somebody who helped, like sometimes authorship on a paper can be. It is something that is legally defined and is something that a patent attorney should review the facts of who worked on the technology and then determine who should be inventors. This is important because in the US, if inventorship is not correct on an issued patent, that incorrect inventorship can be a basis for invalidating that patent. So we try to get inventorship correct so that your rights are protected and that someone who you're trying to sue for infringement can't say, hey, can't sue me, your patent's no good because your inventorship is wrong. So that's why we really take that seriously. And then the inventorship, the ownership originally vests in the inventors, but that ownership can be transferred by assignment. And I'm not going to go into that right now. One thing that is becoming important in the United States and is a complex area of the patent law is this idea of patent eligible subject matter. So that is what can even be considered for patenting in the United States or around the world. And this is one area of the law that is I think quite different around the world, or has some differences that are important to remember. I think maybe Dan will go into this in more detail later. So the United States, you sort of start from a position of essentially most things are patentable. Everything is patentable. And then there are these particular carve-outs that say, except not this, or except not this. For instance, there are some statutory, so things that are in law that say you cannot patent a human. Okay, so that's like, you can patent everything, but you can't patent a human. And then there are other bits of law that say, okay, you can patent everything, but you can't patent technologies that are related to atomic weapons. So sort of from a ethical point of view, we don't want to induce people to make atomic weapons. And then a major point of the law in the US that is changing, has been changing for about a decade, is continuing to change, is how the courts and the patent office are dealing with these things called judicial exceptions. So these are exceptions to eligible subject matter. So things that are not patentable that have been recognized by the courts through the past decades that are now starting to be more solidly in some forms, less solidly in other forms, recognized as needing to be addressed by the patent office. And these have to deal with natural products or things that are laws of nature, say, physical laws, or things that are related to physical laws, like where does the invention begin if you use a physical law, say, F equals ma, that's a physical law. How far beyond that, implementing that into an actual technology that is usable, does a person have to go to have something that's patentable? This also, interestingly, has some relation to free speech. There are ideas that you don't want to create a patent claim or allow patent claims through that prevent people from thinking things, right? How do you don't want to legislate activities in the minds of people. You want people to think about what they want to think about, and how do you even prove that someone's infringing a patent claim if it's what they're thinking. So things that are called mental steps, processes that are only or that can be performed in the mind of a person. There's been some pushback on those types of technologies. Going around the world, there are often moral and ethical issues that exclude things from patentability. For instance, in Europe, anything that is considered contrary to morality or public order is not patentable. In many jurisdictions, methods of treating a human, so therapies, are not patentable. There are some ways to design claims that get around that, or at least partially get around that. But the idea there is that some countries don't want to punish doctors for trying to treat people, which seems reasonable. And then Dan will get at this later. Plants and animals, to some extent, are not eligible for patenting in several jurisdictions around the world. So Europe, Canada, China, South Korea, India, and Russia. There are also issues of biopiracy, intellectual colonialism, and cultural appropriation around the world for companies going into other countries and trying to patent things that, say, have cultural or social significance in countries around the world. One example of this is what was called the neem tree patent. It's an old story about a US company trying to or had a patent on extracts from the neem tree, which is a tree in India that is held in high regard for its healing properties and has cultural significance in that country. How much time do I have here? I've got about five minutes. One thing that is very important to understand is that having a patent does not give you the right to make or use your technology, okay? It gives you the right to prevent others from making or using that technology. So your claim, it doesn't obligate you to do anything. You don't have to make or use your technology, but it doesn't give you the right to make or use it. So in this Venn diagram, I've tried to show this, where in the pink circle, this is some scope of a claim that protects a technology, and it allows you to prevent others from operating in this space. Your product is the yellow circle, which hopefully falls somewhere within your claim, so you can prevent people from making, using, selling your product. But in some instances, there might be a competitor who has a claim that might partially prevent you from making a part of your product or performing part of your method, in which case, even though your claim covers your product, if you made that product, it still might infringe somebody else. So this ability to make and use and sell your product without or with minimal exposure to lawsuits, this is what we call freedom to operate. So that's FTO. Freedom to operate is how free are you to make and use a technology without being sued by somebody else? And that's a distinct question from, do I have something that is patentable on its own? And those things should be kept separate in your mind. So this can be shown in the complex world of smartphones, where there are many companies involved in the world of smartphones that have patents to, bits of technology that are all, in your smartphone. But any one of these makers needs access to, a suite of those technologies. And so all these companies have bits of patents, and they're all licensing and suing everybody in this complex web of technologies for smartphones. And that's an extreme example, but it kind of shows that there are these complex rights that people have and that people need to be able to develop technologies in various areas. So after you have a patent, and you are able then to enforce your patent. So this means I have a patent claim, and what is important to understand here is that this right that you have in a patent is given to you by a government. Okay, it is a civil. It is under civil law, which means that infringing a patent is not a crime. It's not something you've done against the government or the state. So the government doesn't police infringers. They don't enforce patents. If you have a patent, it's up to you to monitor your competitors, monitor the technology space for potential infringers. And then it's up to you ultimately to then start a lawsuit against an infringer. So it's up to the patent holder to act. The government does not act on a patent holder's behalf. And in that, a patent is a piece of paper, right? So you have a patent, it is in some respect only worth as much as you are willing to enforce it. Are you willing to stomach the cost of a lawsuit? Are you willing to stomach the drain of resources and time to engage someone in a lawsuit or engage someone in a discussion to negotiate a license? And this is important around the world too, where court systems around the world have various degrees of predictability, various degrees of treatment of people within the country and outside the country. There might be some biases around the world. So the point is just having a patent is, that's one step. But then the other step is, how much does it cost to enforce those rights in courts around the world? How do the courts treat patent cases, et cetera, et cetera. It can be very complex and expensive after you have procured your patent. So I'm going to then just get to my final slide here, as I think I'm running out of time. And a common question among people that are interested in patents is, how much is this going to cost me? Okay, this is a very rough estimate of costs for how this would happen in the US. So for a patent attorney to write a patent application, depending on the complexity of the technology and how much work is done by the inventor and the researchers, these days can range anywhere from, say, $7,500 to $20,000 for the time it takes to draft the patent application. And then after you've drafted and filed that application, then there are costs involved in the prosecution stage. So interacting with the patent office, writing arguments saying, hey, patent office, you're wrong, my claims are patentable, et cetera. And these costs then vary around the world depending on how rigorous the patent laws are in different jurisdictions, and other considerations. So you can see that they vary anywhere from, very, very roughly from $10,000 upward to maybe $50,000 in some jurisdictions that are more costly. There are annuities, which are essentially taxes that must be paid to keep a patent alive after you have it. So you can think about an average of $10,000 per application over the lifetime of that patent. And then if you want to try to enforce that patent, getting to litigation and enforcement, that can range, in the millions of dollars. So it's an expensive an expensive game to play after you actually have your patent. And you can see just procuring your patent, if you're interested in international rights, can get upward of hundreds of thousands of dollars. So it's expensive, it's complex, and we as patent attorneys, it's our job to help you understand the risks and the benefits from a commercial standpoint and from a financial standpoint for going through this process. So that's what I have. I'll turn it over to Dan, and I think perhaps at the end of both of our presentations there'll be some time for questions. So we hope that you do have some questions.
So thanks, Tom. Very useful information. We do have a question I think we'll address right now. Pat Schnabel asked, we've heard that IP protected by patents based on research that is funded by the US government, for example, the technology behind the COVID vaccines, can essentially be nationalized. Can you say something about this and how common it is? And actually, Christian Tobias from NIFA has put a comment, a response to that also, that IP developed with funding from the US government during the period of a contract or award must be reported to the government, the Bayh-Dole Act.
Yes. So this is something that is often called march-in rights. So in the US, if you have developed a technology that has been touched in any way by government funding, then the government does have rights to that technology without being considered an infringer. In practice, I've never seen that happen in anything that I've worked with. Typically, I think would only happen in instances of, I would say very, very important technologies like a COVID vaccine or something where there's a very compelling government interest to make or use a technology that is patented by a non-government entity. I don't have a complete understanding of that because, as I said, I've never had to actually deal with it. So I don't, there are cases where that has happened or could happen, but I have no experience with that.
So Tom, to my knowledge, it has never happened in the US. It exists as a potential sort of eventuality that could happen. It has happened in other countries where there are similar types of march-in rights, but the way it tends to happen is that the company that owns the patent is not doing it. It's not actually producing anything covered by the patent. And it's the existence of the patent is precluding people that could produce whatever is needed from doing so. And what the government will do in those cases is come in and say, look, we are authorizing anybody who would want to produce a product that would require this patent to do so without infringing the patent. So it's sort of the government essentially removing that sort of monopoly that they've granted for the sort of limited purpose of satisfying some sort of immediate need.
Yeah. Yep.
So, but as Christian points out, and Christian, if you're on and you want to say more about it, you just please speak up. It does have to be reported to the government.
Yes, that's true. And also you have to put it in the patent application.
Yeah.
You have to put it in the first paragraph of the patent application that the technology or any claims are covered or are subject to certain rights by the government.
Yeah. And that's typically the reporting part is typically handled by university tech transfer offices or compliance departments, in private entities. That reporting is not anything I've ever done. It's typically happened, by the patenting entity, whoever that is.
Christian, you don't want to say more about that?
I'm on the same page as Tom here. I'm learning about this as much as anybody. So my sense is that one uses this IASIN platform
Right.
for reporting these inventions.
Yeah.
Okay, well, important point. All right, I think we'll move on to Dan. So Tom, if you want to stop sharing, and then Dan can share, and we'll have him give his presentation. And again, if you have any questions, just put them in the chat.
Is that looking all correct?
Yes, excellent.
Thank you, Jack. Thank you, Tom. So as Jack mentioned earlier, my name is Dan Lorenzen. I'm Chief IP Counsel for Genus PLC. So right up front, I'm going to sort of put in this disclaimer because I'm going to be talking about sort of specific patents and specific protection schemes around the world. None of this is intended as legal advice. That's important for me to put out there just as an ethical issue. None of this should either be construed as the position of Genus PLC. We operate in this area, so a lot of this is sort of my personal opinion. So don't think that sort of any of this is necessarily how Genus PLC as an entity approaches these issues. Having said that, I'm sure many of you wouldn't be necessarily familiar with Genus. We are an agricultural biotech company based in the UK, but the parts of the company that people may be familiar with are sort of the commodities companies in the US, both of which are based in the US. So we have a pig genetics company called Pig Improvement Company, or PIC, that is based in the Nashville area, and ABS, which is a bovine genetics company that deals with both dairy and beef genetics that is based here in the Madison area. I myself have been with the company since 2016. And as Jack mentioned, my background is in biology. We have a variety of technologies that we deal with, sort of genetics, trait development, reproductive biology, and also a bunch of like cool laser stuff that is sort of beyond my level of expertise, but that I also deal with on a regular basis. But we are sort of both a genetic company and an R&D company. Now, sort of having gotten through that introduction, as Jack mentioned, as Tom alluded to, I'm going to sort of start off a little bit talking about, academia generates a lot of new technologies, a lot of new innovations, right? The sort of academic research is sort of what it does. But there's sort of, not always this conception about turning those developments and those innovations into IP. And from the industry perspective, I want to sort of talk about why it's important that academia do that and what the value is sort of driving in both directions, both the industry and then coming back to academia from being able to utilize IP developed from academic research. I want to sort of frame this as Tom alluded to, or as Tom sort of went through in some nice detail in the Constitution, right in Article 2, there's the IP clause that specifically says that the reason we have IP and patents in particular is because we want to promote progress. But there can often be this view that there's a tension between academic research and industry in terms of what that progress actually looks like and why we are trying to progress science and technology, right? And from industry perspective, it's pretty clear cut that we're trying to meet customer demand. We're trying to, improve customer-facing commercial products, right? At the end of the day, that's what we're trying to do. The academic perspective is pretty different, sort of from viewing it from that standpoint, and it is we're trying to, like, as a pure endeavor, progress scientific understanding. That's right. That's the entire point of it. And so if you look at sort of this from a holistic perspective, those are both ways to progress science with sort of different ends, but they're not totally separated, right? They feed into each other. So there's this apparent tension. But as IP is generated, like, so to back up a step, this advancement in academia often comes in the form of like publication and presentations, right? That PIs want to get their work out there. They want peer review. That is sort of the end goal in many cases. And this comes in the form of collaborative work amongst organizations, research institutions, people with areas of expertise you'll reach out to, and they know how to answer a specific type of problem for a project that you're working on. Free flow of information is often sort of the baseline for academic research. to the extent that patent filings are made and patent applications are filed, they're tied to sort of breakthrough discovery and proof of concept, sort of technological improvements, right? And this result in IP that's really sort of foundational, but not necessarily commercializable, at least not sort of at the time it's filed or even granted. And a lot of these advancements in technical and IP improvements are often sort of these leaps, like big jumps, and can be potentially disruptive for industry, right? And in some cases, this results in spin-off startup companies that are sort of disruptive to the entire market. In other cases, it results in industry sort of taking some of these big disruptive technologies and trying to turn them into commercial products. The view from industry is a bit different, that what industry is really interested in at the end of the day is competitive advantage and exclusivity in a lot of cases. So as Tom went through, the patent right is really a right to exclude others from practicing the claimed invention. So if you have rights in that patent, so let's say the university owns a patent, but an industry partner is licensing it on an exclusive basis, that means no one else can practice that patent except the entity that has licensed that technology. So that means that that industry partner has a competitive advantage over their competitors in the market, right? It can also provide freedom to operate, so that can be a big concern. You don't, in the same way that that a company wants sort of exclusivity, they also want to not be excluded. So that can be a big part of what industry is looking for in IP. And often patent filings coming out of industry are tied to the commercialization product and ultimate commercial products, not sort of these big foundational leaps. Although that can happen, they tend to be more toward the iterative, stepwise improvements and things that are implementable and heading to market, right? So where do these two meet? Well, a lot of times industry isn't really necessarily capable or have the capacity to undertake these really foundational questions. And often academia, when they do have patents around some of these foundational technologies, are looking for a partner and looking to generate a revenue stream. So if they own the IP, industry can utilize that IP in order to eventually make a commercial product. That commercial product will have tied to it a royalty that is paid back to the university. So it's a way for the university to generate revenue that is attributable back to the foundational sort of research that is going on at the academic institution. And as Tom said, there's a lot of costs associated with prosecuting and potentially trying to enforce a patent, right? So in a lot of these licensing agreements, industry will take over that cost, and so that the university doesn't have to bear it. And that'll sort of be a nice way to balance getting the patent, but not being able to sort of necessarily turn it into a commercial product to generate revenue that would then pay for the cost of prosecuting and enforcing a patent. I sort of put together a chart. I was trying to sort of distill my thoughts around what is sort of driving the valuation of IP in these different settings. And a lot of it really comes down to, right, on industry, as I sort of said, on the industry side, there's a business case that has to be part of the equation. You have to be thinking about what is the ultimate commercial product, what kind of revenue can that generate, and how can we actually extract that from the IP that we have. That's not really like, right, that's not, to the extent that it is a concern ever, it's not an overriding concern in the academic realm. It's really about advancing knowledge and advancing our scientific understanding. And while that's important on the industry side, it is not generally the driving force. Meeting customer demand hardly ever comes up. I mean, maybe it can, right? If we're talking about a specific disease that affects farmers, like there is always concern about how is this affecting farmers. That is something that is, I think, always in mind. But in terms of providing a specific product that meets the demand the farmers want, that's not really why we're on the academic side pursuing this research. But it can be, or very often is, sort of a very high level area of concern for commercial entities. And then there's this sort of idea about hit and miss ratio, right? Like R&D on the industry side tends to be cognizant of how many of these projects that we have going on right now are likely to sort of pay out at the end, versus how many are we sort of investing in that aren't going to yield, we don't think are going to yield anything. And, you know, putting the chips on those places that are more likely to yield an ultimate result, which in academia, it's like, that is sort of an ancillary concern. We want to ask the question because we think that the answer is important, not whether or not like we're likely to find the answer soon. That can mean maybe that can be a sort of part of the equation of how far do we want to push the question, but it's not sort of what's driving whether or not we pursue a particular question. And if you have any pushback on any of that, please feel free. I think one thing to keep in mind is, from the industry perspective, sort of these valuation metrics, if you will, don't apply just to R&D that's going on within the company, but is also applicable to looking at IP that's coming out of academia, right? So looking at a patent that is, or a patent application that's coming out of a research institution and sort of evaluating that technology in terms of all of these factors. Not to say that it's incumbent on academic institutions to sort of lay out that case, but just to keep in mind that that is always front of mind when industry is evaluating academia-derived intellectual property. So I've sort of set out a bunch of ways that they're very different, but I actually tend to think of this more as a spectrum in terms of our research and development generally, right? Academia is really sort of pushing on one end toward the discovery, sort of asking the very fundamental questions. Whereas industry is really pushing on the other side in terms of how do we deliver based on these sort of fundamental breakthroughs, how do we transition that into something we can actually deliver as a commercial product? But these two also sort of feed back into each other, right? Obviously, these new discoveries enable the development of commercial products eventually. And also sort of revenue generated from producing commercial products can feed back into the discovery, right? We do a fair amount of sponsored research and collaboration agreements where we are actually paying for research to answer specific questions that we are very interested in getting answers to, but we don't have either the capability or capacity to address. So the ability for industry to produce commercial products and generate revenues out of them can help feed back into the sort of discovery pipeline, if you will. So with that, I'm going to transition to talk a little bit about, to build on some of the things that Tom talked about earlier in terms of IP schemes as it relate to agriculture generally, plants and animals in particular, and talk about some of those schemes that are available both in the US and internationally, and then point out some key differences between plants and animals where they exist. So I'm going to start with a focus on the US, because that frankly is one I'm most familiar with. So Genus is an international company, so I deal with a lot of international, but like 80% of what I do is in the US. So Tom talked a lot about patents, and that is sort of the primary form of IP with which we tend to be concerned. But I did want to call attention to a couple of other protection schemes that are available. First, I'll talk about utility patents or non-provisional patents that Tom was talking about. And as he said, it's very broad in the US in terms of what is patent eligible. So what can you get a patent on is sort of, I mean, that's it. The limitation in the statute itself, it says any new and useful process, machine, manufacture, composition of matter, or any new and useful improvement thereof. That's incredibly broad. Notably, there's no distinction anywhere in the statute itself about living organisms and whether or not they're patentable. And there's no distinction drawn between plants and animals, with one specific exception that I'll get to in a minute. But as Tom went through, there are these judicial exceptions that are a result of case law from the Supreme Court that have these exceptions to patentability that are sort of broadly drawn as abstract ideas, laws of nature, natural phenomenon, including products in nature. What does that actually mean? What types of things actually fall into these exceptions? Well, generally a gene, just the gene itself, whether isolated or in an animal, is not patentable. Unless that gene is in a place that it would not otherwise exist in nature. And then maybe you can get a patent on that gene in that location. Correlation or cause and effect relationships or necessary outcomes, typically not patentable. So for example, like the ability to diagnose a condition based on the presence of a particular allele, that methodology, generally not patentable. Or providing a treatment based on the presence or absence of a particular metabolite in blood, not patentable. Mathematical equations, as Tom said, generally not patentable. And importantly, plants and animals, as they exist in nature, you can't get a patent on. So you can't just go out and find a strain of maize, a native strain of maize in South America, and file a patent on it, because you didn't actually do anything to invent anything there. You just sort of found a plant that exists in nature, and that is excluded from patentability. Now, if you took a sort of row crop variety of corn and made it sort of either made a hybrid with a sort of native identified strain of maize, or incorporated some of the genes from that, then we're getting into patent eligible subject matter potentially, but just as it's found in nature, not patentable. It also applies to animals. You can't just go find a chicken and patent it. There are in the US a thing called plant patents. So patent protection that is specific to plants, specifically to asexually reproduced plants. And they're granted by the USPTO. They have the same term. The claims look considerably different. I'll show you some of those in a little bit, but it is a specific thing that you can get protection on in the US. In addition, there's plant variety protection, or PVP, which is administered by the USDA instead of the USPTO, at least in the US. And that applies to seeds, tubers, and asexually reproduced plants. They look quite different from a patent application, but they provide a similar type of IP protection in that the owner of that PVP certificate can preclude others from growing or selling that particular variety for which they have obtained a certificate. Other jurisdictions, so ex-US, generally the schemes kind of look the same, right? There's patent protection in almost everywhere in the world. There's also plant variety protections in a lot of jurisdictions around the world. So PVP protection is actually part of an international convention on the protection of new varieties of plants administered by the UPOV. There are 78 member countries, of which the US, the European Union, a bunch of individual European countries, China, UK, Japan, Canada, Mexico are all signatories. So in all of those countries, the protection under the plant variety protection regime looks essentially the same as a matter of international convention. Patent protection, there are also international conventions around, but they tend to, though that convention doesn't really delineate what is or is not protectable, or how countries can make determinations about what does or does not qualify as patent eligible subject matter. That's left up to individual countries. And so it varies pretty significantly around the world. The US is actually somewhat of an outlier in that there aren't specific restrictions statutorily to patenting plants and animals. As Tom said, in the EPC, the conventions that set out the law, essentially the laws for patentability and obtaining a patent in Europe, there are specific statutory preclusions for plant or animal varieties, or essentially biological processes for the production of plants or animals, right? So you just, as a starting point, you cannot get patents on those. This has been refined through some court decisions, but sort of they just started from that point. China similarly has a prohibition on animal and plant varieties. How far this extends is a matter that is being currently pursued. I think nobody really knows what this means ultimately, but it is there in their Patent Act. Canada, their sort of definition of what an invention is looks pretty similar to what the US has, but their Supreme Court has essentially said you cannot include within this list higher, that is multicellular life forms. So that means basically any plants and animals are excluded. It's a matter of judicial edict rather than statutory language. So what can be protected? I think I'm going to start with transgenic organisms, because as I said, I think conceptually this is relatively straightforward. These are plants or animals that have been engineered specifically to contain and express genetic material that's not there under naturally occurring conditions. So a person has made sort of a very specific and identifiable modification by adding a transgene, generally, and obtaining a new phenotype. So what do these tend to look like? Well, this is one issued relatively recently. So transgenic soybean plant encodes as protein and sort of spells out the various aspects of that protein, but it's transgenic. It's right there in the claim. These get issued also in Europe. So transgenic, this is a European equivalent of that same one. Transgenic plant cell that has an isolated polynucleotide that encodes protein. You can also get transgenic animals. This is a tetrafish that encodes, I believe it's a blue fluorescent protein. So a blue glowing tetrafish, patentable, got a patent on it. The USPTO issued this patent in 2018. Similarly, in Europe, transgenic animals are patentable. So this is the CFTR, or the cystic fibrosis model pig from the University of Missouri and University of Iowa. I pulled this one because my thesis project, I used some of these pigs, so near and dear to my heart. But patentable, US, Europe, sort of, I think this is pretty well settled that you can generally get a patent on these animals. I will say, it's not clear whether you could actually get this patent in China. I don't know for a fact that you could, because it is still an animal. And if it is as broad as the language in the Patent Act seems to indicate, that may be precluded entirely regardless of whether or not there's a transgene or it could exist in nature or not. Then this sort of, I'd be remiss if I didn't include a Monsanto patent for resistant soybeans. I think everyone's pretty familiar with this technology, but like this has existed since the 90s. People have been getting patents on these types of plants and animal transgenics. Gene edited organisms. This is, I want to differentiate between gene editing and transgenics. I think there's a subtle difference, but an important one in that transgenic animals incorporate some genetic material that would not otherwise be in that animal. Whereas when I'm talking about gene edited organisms, what I'm referring to is organisms where there's been a modification to the existing genetic material to result in a phenotype that wouldn't otherwise be present, but isn't otherwise introducing additional genetic material that would not otherwise be present. But that being said, they're not really treated any differently under the patent law, because the result of the gene edit is that the animal exists in a condition that is not found in nature. Some person has taken specific action to make a modification. So here's one from the University of Missouri, pretty broad claim. Genetically modified swine comprising an inactivating mutation in an allele of CD163. This is for PRRS resistance. There is no naturally occurring PRRS resistance in big populations as far as anybody knows, and no modifications in CD163, or no naturally occurring alleles that would result in a CD163 that would not produce PRRS infection. So that's sort of weird. Similarly, these are grantable and allowable in Europe and in other jurisdictions. So almost the same claim. Also applies to plants. So this is a tomato that has been modified. The endogenous mitochondrial malate dehydrogenase has been modified the same, so that you're not introducing anything new, you're just changing the genes that are already there in order to produce a different phenotype. Basically the same patent as allowed in Europe. So I think the takeaway here is if you're changing the genetics of a plant or animal in a directed way that is sort of changing that results in a phenotypic change generally, that's going to be allowable patent eligible subject matter kind of wherever you are, with some exceptions. But like I think as a general concept, this is sort of treated as allowable subject matter. Gene editing technologies, I'll just touch on quickly. These tend to be fairly agnostic of what type of organism is being edited. So there aren't really differences between plants and animals, but generally, right? So this is the CRISPR-Cas9 patent from Broad Institute. Here's one from University of California. Similarly in Europe, those are all sort of allowable, right? They're technologies and methodologies used to do the gene editing, often can be implemented in agriculture, or sort of more widely ranging than that, are often used or are sort of thought of, I think in a lot of cases, primarily as human therapeutic type approaches, but are being currently pursued in agricultural spaces, generally protectable, patent eligible subject matter. Stepping away from patents for a second and going back to sort of plant variety protections, if we're thinking about protecting germplasm, that is the genetics of the organisms that are sort of the core of your business, thinking from an industry perspective, the core of your business, right? So this could be for seed companies, the varieties of soybean or corn or wheat or what have you that are being developed through internal R&D. Then how can we protect that germplasm? So PVPs are sort of your first option. Here's a issued certificate for delicata squash. I picked this one because I ate some delicata last night and it was delicious. But this looks a lot different from a patent in that you have to sort of describe the plant. There's not a claim, you're just claiming this variety of delicata squash that has these specific characteristics, and you have to go through and like list out and measure all of these characteristics in comparison to the nearest sort of representative comparator. So some other delicata or some other squash that you can sort of look at things like resistance to fungus and the size and color and shape of leaves and the fruit and how they develop. But that's not just for like things like squash, right? Here's some for, what is this? A wheat variety from Pioneer Hybrid. Here's one from North Dakota State that covers a soybean variety. So like all types of plants can be covered by PVP. They give a term, but they're not defined by anything other than that really what's in the certificate and this particular variety. Importantly, plant variety protection has, there are some provisions within the sort of statutes and enact plant variety protection that allow you to do some recovery or prevent other people from doing this. But if you really want to be able to swing a big stick around your germplasm and prevent, like really have infringers face material consequences, what you want is patent protection. The most straightforward is something like a plant patent protection, wherein all you do is describe a plant, like it's a particular type of patent application, you file at the USPTO, wherein you, in the same kind of way you would for a PVP, you describe everything you can about the plant. In some cases, it's not entirely forthcoming. You can file things under trade secret with the USPTO for plant patents so that the examiner can look at it and be assured that it's a new variety of plant, but that doesn't become publicly available. But the claim looks like this, right? If you look at the one on the right, it's just a new and distinct variety of strawberry plant named QBC1 as illustrated and described here. So generally the application will have some description of the plant and then a bunch of pictures. And that's essentially the definition of what is protected by these. But these have the same, like, right? Plant patents are treated as sort of the same as utility patents in terms of patent infringement, the same types of sort of injunctive and royalty type relief applied to plant patent infringement, but limited in terms of what is actually you can get a plant patent on in a lot of cases. And as I said earlier, and as Tom talked about, there's no actual prohibition in the US statutory framework for patent protection that would preclude filing and having granted a patent, a standard utility patent for a plant or animal variety. In the sort of 90s, a bunch of seed companies took note and realized that they were making a fairly sizable investment in their R&D to develop new varieties, and thought, well, we may as well see if we can get patent protection around these, because then that will really provide us the ability to effectively exclude our competitors from taking our varieties and passing them off as our own. So they started filing these patents, and in 2001, so a bunch of these got granted. In 2001, the Supreme Court decided a case called JEM Ag Supply versus Pioneer Hybrid that found that, yes, in fact, these are patent eligible. You can get patents, at least on plants. It was sort of the language of the decision is because they were talking about patents on plants was sort of limited to plants. So at the very least, you could get patents on plant varieties, standard utility patents. So those claims tend to look like something like this: plant or a seed of a soybean cultivar. And then in order to sort of meet the description requirements, all you really have to do is take some seeds and deposit it with a deposit authority that's been sort of signed off on by the USPTO. Applies to cotton. People have gotten patents on cotton varieties, wheat, sort of any sort of varietal you can think of. People have at least tried to get patent application or get a patent granted on it. This is one of the patents that was at issue in JEM Ag Supply. This was actually filed in what, 1990, I think. Granted in 1986, litigated in 2001. They're a little bit before that, but this is right, hybrid corn plant. So these have looked ostensibly the same for a really long time. And there's really been no question about whether or not these are patent eligible subject matter. So a couple of things to note, I think, at this point. First, these are all in the US, right? This isn't something that happens in other jurisdictions. I think, as we talked about, there's in many jurisdictions prohibitions on, just statutory prohibitions on trying to pursue these types of patents, and in others jurisdictional or judicial limitations on what is patent eligible. And so these really don't exist anywhere outside the US. The other thing you may note is these are all on plant germplasm. And that is mostly, I think, because people haven't tried it in animals yet. And there's probably some pretty good reasons. I will say, we have tried it. So we got a patent issued just sort of as a test case. One of our sort of really high value bulls, we did file a patent application and got a patent granted. So the reason we wanted to do this is because we, like seed companies, put a lot of effort into R&D around genetic improvement in our animals. And the idea being, we sell the genetics, but we don't want competitors to sell our genetics, into which we have put all of this effort in sort of for producing this genetic improvement. And so we don't have this patent anymore. We let it go abandoned because really this was an effort to see if there's any difference ostensibly in the law between plants and animals. And as far as we can tell, there doesn't appear to be any fundamental difference from the patent office perspective, which is sort of how the patent laws are borne out. But there may be sort of important differences just in terms of the way plant germplasm is generated versus animal germplasm, right? Particularly on the bovine side, this is very sort of open genetics. We're in for, practically the entire existence of the bovine genetics market. Competitors have sort of bought genetics from each other's bulls, and that has gone then into their breeding programs and what have you. That is changing pretty rapidly with the industry. And so if the genetics close off and we're all sort of with our own proprietary germplasm, the importance of being able to obtain patents like this may become more important. That's sort of TBD. On the plant side, right, the sort of the way that the plant varieties were produced is sort of through these crossings and internal germplasm production that was completely like closed off within these companies. And so that is sort of the reason they pursued these types of patent protection in the first place. I think the take home here is that it seems, so unquestionably, plants are patent eligible subject matter, presuming you can meet the other requirements of the patent statute. And it appears that animals also would fall into potentially patent eligible subject matter. There are some pretty significant issues with respect to meeting some of the other requirements for the patentability, not patent eligibility, but that's sort of TBD. So to summarize everything that I just went through, to sort of circle all the way back, right? Academic research and IP really helps to drive industry progress. Industry is not always equipped or capable of asking the fundamental questions that are sort of make these big leap and disruptive changes. But the IP coming from academia is an important foundational basis that allows industry to provide sort of these innovative commercial products. And then that does feed back into academic research. And so it's a nice sort of, I won't say perpetual motion, but sort of it continues to feed back on itself. There are important international differences in biological IP protection. The US is generally permissive. There are very strict preclusions in other jurisdictions, as both Tom and I've talked about. And then there are some notable differences between plants and animals within the US in terms of protection schemes and what can be protected. There's more sort of schemes available for plants generally, including plant patents and PVP. Transgenic and gene edited organisms are sort of not just in the US, but globally sort of broadly protectable for the reasons we talked about. And then germplasm this seems to be pretty much a US specific phenomena. Plants definitely protectable. Animals probably, possibly protectable. The value of that we don't really, I think, fully understand yet. So with that, if I'm reading the time right, I think I hit my mark, Jack.
Yeah.
Take any questions.
Great, thank you very much. Again, very, very useful information. And there's a couple of questions in the chat. Pat Schnabel asked about a couple of patentability issue or cases. So he asked, well, what if you added a plant on an animal to create an allele that already exists in that species, but not in the haplotype that it was edited? Is that patentable?
So the classic lawyer response, right? Maybe. It depends. So the method of producing that new allele is probably patentable. So, you know, the targeting and the provision of the editing machinery in order to produce the allele is probably patentable. The existence of that allele in an animal, that's a much closer question. If you could, because there are ways to get that allele into that animal that do not involve editing, right? So there's sort of two questions. One, is it generally patentable? Maybe. Would it be enforceable? That would be tough because you'd have to demonstrate that they actually made the edit to get the allele in. Whereas if you just introgress that allele into that population, it will look the same. Like you won't be able to differentiate between that and the edit. And unless you can prove that they made the edit, how do you prove they infringed that patent?
Yeah, and there's an example in cattle actually with the pole gene, right? Not growing hordes. There are some breeds that have that as a natural mutation. The Holstein doesn't have that. The Holstein dairy cow, and they by gene editing they produce that. And I don't know whether that was patented, but this also brings up the point: getting a patent is very different from being allowed to commercialize it, right, or market it.
Yep.
That's the issue with a lot of the gene edited animals.
I think also it's important to remember, and Dan and I talked about this, but there's one issue is a technology eligible for patenting. So that's sort of a threshold issue. And then if it is, it still has to meet other requirements of, is it novel? Is it new? Is it not obvious? Is it described appropriately? So sometimes those, well, often they overlap, but they are distinct requirements. So for instance, for Pat's question, like if it's something that a researcher's created, more than likely meets the threshold of, is it patent eligible? But then the question is, well, is it new? Or there are other things to consider. I think for both of Pat's questions here, the fact that he uses the word created, or if it's something that's made, I think that helps you get to a patent eligible standpoint. It becomes harder, say, if you're just screening for favorable natural variants. I mean, I think from a claim to the plant or animal itself is difficult, but then again, as Dan said, the methods may be easier to get claims on, but then you also run into the issue, how do you enforce that?
Yeah, okay. Yeah, thanks, Tom, and that I think also then addresses the second part of Pat's question. Kurt van Tessel has a question which relates to the patent on the Holstein bull, and I believe there was also a Jersey cow that was patented.
Yeah.
The question is whether that patent was enforced, and I think you answered it because you mentioned that the patent was abandoned, right?
Yeah, so I mean, there's two parts of that. One, we abandoned the patent rather than sort of continue to pay fees on it or anything, or even try to enforce it. I think the enforcement part is like, we didn't think that anybody had the germplasm from that animal. And so that we weren't aware of anybody to try and enforce it against. And like, we also weren't necessarily incentivized to try and enforce it, even if we knew someone had it, right?
Yeah.
So no, the short answer is no.
Okay, good. And then Pat has another question. Not infrequently, we see opinion pieces in the popular press arguing that patents should be eliminated, for example, with regard to drugs. What would be the short and longer term consequences of doing so? And he's pointing out that he's being a devil's advocate.
I think, yeah, there's debates on the value of patents and how it affects research and how it affects commercialization and development. And I think there are valid arguments on both sides. I think with respect to drugs and that process, I've seen it said that may be the most appropriate place for patents to exist as far as the policies, in that the costs of R&D to develop a pharmaceutical and get it to market are exorbitant. And if there was no way for those companies to recoup some of those investments, they wouldn't make those drugs. And it's often, a good case for this is drugs for diseases that don't affect many people, right? And the market's there, right? So that's not exactly a patent issue, but it does sort of explain why market forces can drive and an R&D forces can drive what happens in the drug world. So I'm not saying, I'm for either side of this, but I think that's the pharmaceutical world is one very good instance where you can see that the policy makes sense. At least there's a reasonable argument that it makes sense.
Yeah, and to build on that a little bit, Tom, I think there are incentives outside of the patent system that drive scientific research, right? I think in academia, most of the incentives lie outside of the patent realm. But I think what the IP clause in particular, and sort of embodying this concept, what's really trying to get at is how do we transition those scientific developments into things that actually get to people and actually improve the lives of the population, right? And the way to incentivize that, one way, is through the patent system, which gives holders of the patents the ability to monopolize that technology for a limited amount of time in exchange for letting everybody know how the technology works. Such that once the patent expires, it's free for everybody to use. But it gives, as Tom said, it gives that ability to recoup the costs of taking what is sort of a fundamental or foundational technological improvement and turn it into something that can actually benefit people more broadly.
Okay, thanks. Last question, because we're at the top of the hour, and Donna Karen Harris has a follow-up on Pat's earlier question, and that we kind of glanced over. She says, I'm still not clear when it comes to induced mutations through chemicals or radiation. If this produces a novel phenotype, is it patentable, for example, in Europe?
Not legal advice. And again, like, it depends. Like it very well could be, right? If this is actually a new genotype that results in a new phenotype, it could be patent eligible in like sort of a lot of jurisdictions. And I mean, we've seen similar types of, like, that wouldn't really be fundamentally different from making a directed gene edit that resulted in the same genotype and phenotype, right? Like, that is potentially protectable under the patent law.
Okay. All right, thank you. I think we'll have to close it off here. If Dan, if you want to stop sharing your screen. And first of all, I want to thank Dan and Tom very much for their contributions to this. It was very, very useful. I think a lot of insight into well, a very complex field, and that is very unfamiliar to many of us. So it's been very useful. You can continue the conversation on the Slack channel that's been set up. I also want to remind you again of the field days every third Wednesday of the month. And then there's a workshop that will be held November 18 on sharing UAS-based high throughput plant phenotyping data via public clouds. And then we still have some seed grants, some rolling community event grants and working group grants available. So if you're interested in those, please apply to those. And then some of you may have seen this, but NIFA announced at the end of last month that there's another AG2PI grant that has been awarded. I remember there was an RFP that came out earlier in the year where to request grants close to $2 million for continuing the kind of work that we've been doing over the past several years. And we were fortunate enough, our group was fortunate enough, so the current AG2PI group was fortunate enough to be awarded this grant. It will, most of that will go to the community again, just like so this is the third one, just like the second one. The first one had the field days, and that still funds these field days and the work groups and conferences, and that's still ongoing. The second year was primarily went to seed grants, and in this new one, we're calling them coconut seed grants because we are anticipating or proposing to have larger grants going out to the community. And there's an RFP that is being developed that we should release soon. So keep an eye on that. So there will be lots of opportunities to continue the work you may have started in seed grants or new ideas that you have, but with the larger amounts, you should be able to get more accomplished and go beyond the seed grant process. So we're more information on that later. So with that, I'm going to close it off. Dan and Tom, thanks again. Nicole, thanks for all the technical assistance, and Eddie. And thanks all of you for attending and the discussion. Have a good, nice rest of the day.